Okay. So Cody, this is your work, so thank you.
Yeah. So I said it before we got our full attendance here, but this is what in line with this is what we had discussed before when we went over 410 before. And we had decided to deviate from the ROLCA 410 because we decided that the Oregon policy had been different from what ROLCA was saying. And instead, we had decided to use RCW 25-15-136 as our sort of the base model. So what you see here are red lines from the Washington statute on this. Substantial portions are the same as ROLCA, but there are other significant portions which are different. For example, subsection 1 here is that list of all the documents the LLC needs to keep, which is consistent with Oregon law, and ROLCA doesn't have that, for example. And where you see red lines in this 410 document is showing only deviations from that Washington statute. Almost all of the deviations are either to mirror something in present Oregon law, such as you can see subsection 1J there. That's something that's in Oregon law. The other changes that you see are basically putting ROLCA provisions that Washington did not adopt back into it. So that's the core of what the changes are. Yeah, that's basically it. There is this down, well, you can't see it right now, but when we get there, there is one section, subsection 13, that is not in the RCW, but that comes from ORS, and I can talk about that when we get there.
Right. So I reviewed it, and I think that the changes make sense to me, but Sandy, let's start at the top and just walk through. So section 1 basically says this is where you need to keep the records. But my understanding when we talked about this before is that a lot of these things can be varied by the operating agreement.
That was something that we have not reached a decision on. 105, it provides that the members, and I'll quote what 105 says, it says that you may not unreasonably restrict the duties and rights under section 410, but the operating agreement may impose reasonable restrictions on the availability and use of information obtained under that section and may define appropriate remedies, including liquidated damages for a breach of any reasonable restriction on use. That's what ROLCA says. That's 105C8, but we had not decided exactly what we want to have 105C8 say. And down at the bottom, I have a little comment about if we adopt.
Go ahead and scroll down, Sandy, please.
At the very bottom of this document that Sandy is sharing, I have a comment about if we adopt, I guess I left the word adopt out there, but if we adopt 105C8, then we had some potential options that we had discussed about what to do here. But also when we had discussed this 105C8, we had discussed, instead of using the ROLCA language, to have it say that the operating agreement may not vary the duties and rights under section 410 except as otherwise provided in that section. And as we'll go through, this RCW based version of 410 talks about certain restrictions that you can put on the availability of information itself. So it doesn't need an additional call out in 105C8. I think so. That's the gist of where that is coming from.
Right, and so that's essentially the guardrail provisions when we're considering this, the adoption of 410 here, is the what restrictions are baked into this. So as we go through it, let's keep that in mind.
Cody, just one clarification. Does the RCW include a language like what you just described that says that you cannot vary this section other than as provided in this section?
Let me check on that.
I'm happy to do so.
Oh, that'd be great. Okay, cool.
Seems to me that makes sense though, because what we're looking at is sort of, for any LLC, how do creditors or prospective members find out about the LLC? And that, to me, seems like it's not something that we should let them avoid by drafting.
Well, I guess let me ask the question here. This really relates to a member's ability to get information, not third parties outside the company. Is that correct?
Right. You know, if you look at 2, it says on 10 days, 2A there, it says on 10 days demand made in a record received by the LLC, a member may inspect and copy this stuff. There is provision, I can't remember if it's in this or if it's in the other section that talks about, you know, what if you do if somebody dies and there's a personal representative appointed, I think, for example. But the gist of it is that this is information, it's not information about the LLC that just a random stranger member of the public can get.
And,
Say that
you
again,
know, I
David.
would presume, I mean, I'm not a litigator, but through, you know, the litigation from third parties and creditors, the normal discovery remedies would still be available to those individuals.
Oh, yes, this is not at all a limitation on what's available through civil discovery in a lawsuit. I'll note that this statute that we're just looking at right now does end up also talking about specifically itself about right to information of a person dissociated as a member. They have a more limited right, I believe, than a existing member.
Okay, so
Oh, so I think most in quoting the RCW, I think that's consistent with what our proposal was for what 105C8 would say.
okay, so the operating agreement then may not vary these or, you know, or restrict unreasonably the right to records. Is essentially what the RCW is saying, right, Mohsen?
Yeah, that's right. It says you can't vary the records that you have to maintain, and you cannot unreasonably restrict the member's rights to such records. So that's similar to what's in ROCA itself. Although ROCA has this additional language, but the operating agreement may impose reasonable restrictions on the availability of use and the availability and use of that information. So I'm not sure that adds a whole lot to just saying you cannot unreasonably restrict, but
Yeah, it seems to be just another way to say that, right? So you
Yeah.
have to give people notice as opposed to just showing up with your team of photocopiers. Okay, so shall we go do a tight reading of this then and then go? So it looks like there aren't really any changes that were made to the RCW version in the first couple sections, which is consistent with my notes. A, B, 2A, not B, A3. So I have a note saying that we decided not to add oh, I guess that's a note about the ROLCO language. Because I think your initial handout, Cody, when we went through this before, was trying to compare, started with ROLCA and then listed the corresponding RCW sections. Does that sound right?
Well, yes, and here, well, and you can't, in the comments, it's showing the red lines, but yeah, wherever there was a reference to an RCW, I changed it to a reference to the applicable ROLCA provision as we've been adopting it.
Yeah. Okay, so anybody have any concerns or questions about subsection A or 1A through 1G?
We'd want to reference articles of organization rather than certificate of formation. I mean, that's just editorial
Right,
issues.
that's a good point. Sandy, can we go in and edit that, please?
Yeah,
So
where was that? I'm looking for it. It's
it's in
A-
A,
1A,
1A.
yeah. So it's an article. It's article of organization.
articles of organization.
We decided to keep the Oregon language, yeah. Made amendments.
And you see it again in C.
Yep,
First,
I see it. Thank you.
Yeah, so that looks okay to me. And then G is just a section update to the ROLCA language. And of course, Sean is going to come in and renumber stuff anyhow. So articles of conversion or merger, and then I and J, current list. Yeah, and that's J is an addition because of the transparency requirements in the ORSs. And then where is B coming from, Cody?
B,
Yeah, so 2B.
give me a second, let me.
Looks like it's RCW 2515-136 sub 6. And then ROLCA sub C is a template on 10 days demand. Oh no, that's the associated
This
one.
is coming from ROLCA 410A2 is what my note says. Is that right? A2.
410.
Yeah, that looks
Oh,
right.
That's
yeah.
That's right.
Yeah. Okay, so that's.
And this is adopting A2A of ROLCA,
Yeah, then we didn't
but
do
not A2B.
right. And that's the note I had before about the not B. So then we pull in C3, which is the duty to furnish information, right?
Yes, and we had decided to adopt this, but say it only applies to member managed LLC.
Right, and that's in my notes too.
Yeah, I had that too.
2C. Okay, so, and then D, whenever this act provides for a member.
And that comes from ROLCA B4.
Could someone explain how B and C interact? Because I'm sure there is something, but it just seems confusing. It says, except to the extent that the company can establish that it reasonably believes, and then it says also applies to each member. Okay, so that means that the member has to supply information. Okay, thank you. Sorry, I was looking at it, it's a little confusing.
One editorial note, every reference to company should say limited liability company.
Have you been doing that all along?
That's, well, that's the Rulka default language, is limited liability company.
Well, yeah, I mean, Rolka often is like in a given paragraph, for example, the first time they'll, I mean, they don't always, so the first time that they
Oh.
mention in a particular sentence, limited liability company, they will say limited liability company, and then subsequent references in that same sentences, they'll just say the company. So, for example, I agree that like 2B should start out by saying the limited liability company shall furnish. But then subsequent references to company in that same B
Paragraph,
section would not need that.
Yeah, so
Although
Sandy, in front of, in B, after the word the, add limited liability company, please.
Okay.
Although just noting that in A, it says limited liability company several times. So it doesn't
but this
follow
is-
that.
This is something that Sean can deal with.
Yeah.
This is not something we should need to worry about. But let's try and be consistent when we start off our sections. Okay. Anything else on page 1? Okay, let's scroll down, please, Sandy.
Cody, back on page 1, where did subpart D come from?
D, 2D comes from Rolka B4, 410B4, which says whenever this act or an operating, I mean, it says what it says there. It's like a copy and paste job.
Okay, scroll down. Okay, 3 regular business hours. C, where is C coming from here?
So C is coming from Rolka B2.
And inspect, yes. Yeah, and then 6, yeah. 6 makes sense. Because that's that additional associated number stuff.
Cody, on the previous part, it's no longer on the window showing here, but you said it came from B2. B2 also includes this proviso that the member can inspect such information provided the member seeks the information for a purpose reasonably related to their membership interest and the member makes demand with reasonable particularity as to what they want to see.
Go ahead and scroll up, Cody, please, or Sandy, rather. Stop.
Is there a similar particularity requirement anywhere in here?
You see how it says at the top of 3? Can you scroll up more, Sandy, please? Do you see how 3, it says during regular business hours and in a reasonable location specified, blah, 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 if the member meets the requirements of subsection 4 of this section?
Sorry,
And then look at subsection 4.
I see it. Thank you.
Uh-huh.
Anything else in the top half of this page? Yep. 6.
Okay, sorry, I was trying to unmute. I couldn't find myself. So I
You
don't
want to
think.
go back to the top half of the page, Roberta?
Yeah, I don't think it really matters, but it looks like in Rolka, it defined it, the things that are in in the subsection under ROLCA defines what is just and reasonable. And here we just say, we're not using number 4 as defining what is just and reasonable. We're just saying they can do it under these circumstances. So I wonder, I don't think it's really material, but I wonder if it sort of leaves the door open to having other things being just and reasonable, or maybe ROLCA was just not intending an exclusive list as to what's just and reasonable.
You're saying that the need to have a purpose reasonably related to your membership interest and to have the particularity and the connection with your purpose, that you're saying is defining what it means to be just and reasonable?
No, Roberta, I think that perhaps you're misreading. So
Could be.
both 3 and 6 point back to, well, 3 and 5 rather point back to section 4, which is on page 116 of ROLCA and includes the language after the just and reasonable clause in B2. So we do have the A, B, and C of ROLCA in here.
Oh, no, I see that. I do see
Okay.
that, but it does seem to say is just and reasonable if in ROLCA.
Mm-hmm.
And it does not say that in this edit. And I
Oh.
don't know if that's significant or not, but I just merely pointed out that in
Yeah,
ROLCA,
I don't, to
be
me, it doesn't
defined.
seem significant because I think because they both refer to the same restrictive language in 4, right? It points you back to the same place that the ROLCA language would have. So from, at least from my perspective, I think that that's sufficient coverage, sufficient guardrails on that. Of course, other people may disagree.
I read it the same. I don't think it's making a change compared to ROLCA in this regard. I read the just and reasonable as talking about the scope of the other records that you can get if you jump through the hoops of what here is our section 4. I don't think just and reasonable is referring to the manner in which you request the information. I think it refers to the scope of the information you can get.
I don't disagree with that. I mean, and I'm fine with it. I just merely, to me, it looks like that word if in ROLCA looks like it's defining just and reasonable, but I don't, I'm not, going to die on this hill. I just thought I'd point it out.
Yeah, I think that the if at the end of section 4 serves as a similar parallel, but I do take your point that it doesn't have the sort of definitional feel of the ROLCA language. Okay, can we scroll down to 6? Okay. That 10 days is the same 10 days from ROLCA to C, it looks like.
Yeah, this is sort of a blend of ROLCA 10 with the RCW.
Yeah.
Or I mean ROLCA C, I'm sorry, ROLCA C with the RCW.
Yeah, on page 117.
And here's where the if migrated to, apparently.
Well, it's another if, right?
It's an if.
Yeah. Yeah, and I think that's it has the language that I care about, which is that that it relates to the period which they remember. Yeah, it has a good faith requirements and then the requirements imposed by section 4. So I think that's fine. 7, I think 7's fine. 8.
This is a meld with we're blending in ROLCA H into this provision.
Yeah, although I had crossed out ROLCA H.
Well, yeah, but I mean, we aren't adopting ROLCA H, verbatim.
Yeah, and I think that's confidential disclosure. And it's not proscriptive. It just said, they may impose reasonable restrictions, which I think is the important part.
Yeah, and I'll just note, Mosen had put that language up of what the Washington version of 105C8 says, which is you may not vary the records required under subsection 1 here, or unreasonably restrict the right to records or information under 410. And then, I mean, this is sort of like where, I don't know, maybe it's important to say it twice, but it seems to me it's kind of saying it twice a little bit when you look at 8 here, where you may impose reasonable restrictions on the use of the information. But I guess this is, I guess one difference is that 8 is talking about the use of the records and information. It's not the availability. It's about, you can put these limits on the use of it, and sort of specifically authorizing that. Whereas I think their 105C8, I take it back. It's not talking about the same thing. 105C8 is talking about your right to get the records and information. And this subsection 8 here is talking about your use of the records and information. But they're both allowing you to put reasonable restrictions on that.
Okay, and then
Oh, yeah, I think you got it right the first time. That 105C8 says the operating agreement may impose reasonable restrictions on the availability and use of the information obtained under this section. So it does seem to say it twice. As a drafting matter, that's bad practice, but it seems to be harmless here.
I agree. I think they, in large part, get to the same point.
sounds good. And then the charge thing is an ORS restriction, so that's fine.
Yes, that comes from ORS.
Attorney, legal representative. I would only suggest that including an attorney or in the case of an individual under a legal disability, such individual's legal representative. And so instead, yeah, substitute such individuals for a legal representative.
Huh? So this is blending with Rolka F. And the way Rolka F reads is, in the case of an individual under legal disability, a legal representative.
Yeah, I don't like that language.
Valerie, is that the way I typed it? Is that how you'd like to see it?
Yes, it was one fewer space after the S.
Ah, yes.
Because I think that we need to just clarify who's legal representative there, because we're talking about who has the access rights to information.
So we're just replacing with such
Yeah.
individuals.
Correct. Does that sound okay to everybody?
I think that's a good change. It makes it more precise.
Okay. Yep, okay. Anything else on page 2, going to page 3? So subject to section 504. Oh yeah, that's the legal representative.
Yeah, and this is Rolka G, which is why the subject to section 504 is added.
Right, that makes sense. Yep. Okay, and then 13 is ORS, right?
Yeah, that's ORS 63.781.
Yeah.
And the changes from that statute is that statute talks about records, but here, whenever it talks about records, we've added information or, since Rolka and RCW talk about information or records. So just keep it consistent.
Yeah, that makes sense to me.
I guess I need to pause us here. You're saying this is verbatim 781?
Is that not right?
Let me pull it up.
Okay,
I thought that's what it is. That's what my notes tell me it should have been.
Court ordered inspection.
It looks like it is.
Yeah. Yeah, just with the numbering change to be consistent with the ROLCA. Sandy, can you insert, well, can you scroll down to the comments and just confirm that we have a comment about 13 being pulled from this section?
Let's see.
Okay, let's add a bullet point comment here.
Yep.
No, I mean, I think add under the add comment section.
Oh, yeah, right here.
Well, no.
Oh.
So we have a list of bullet points.
Yeah.
Okay, let's add a bullet point after the,
After the last one.
no, go up.
Oh, sorry.
No, there's one more bullet point on that last page, right? Okay, so you see the bullet point that says consistent with?
I do.
Okay, so let's add a bullet point after that paragraph. That says 13 is intended to pull in the 63,781.
60, sorry, 781. What was the
63.781.
63? Okay.
And that way, Sean, if Sean needs to massage anything, he can do that. Thank you.
No problem.
Do you want to scroll up? Does anybody want to take a look at that again? Any other questions or concerns about this 410? Thank you so much, Cody, for pulling.
Thanks,
this all
Cody.
together.
Yeah. And then I guess the last question is, what do we do about 105C8? And it strikes me that the Washington language would work well for us.
Okay, so so let's go back and to the draft.
And Mosin
one.
put that language in the comments.
Yeah, so let's
I'm gonna go back to the main bill.
our draft. Yeah.
Yep, I have it up. Just give me 1 sec.
Cody, I would still prefer, I think the Washington language is a fine starting point, but I would still prefer to include this proviso that's in ROLCA that says, comma, but the operating agreement may impose reasonable restrictions on the
Yeah.
availability and use of
So
information.
Mosin, let's wait till Sandy gets that up.
Sorry, I just had.
That's fine. I'm not saying this for the purposes of putting
No,
it.
I'd rather us
There
look
it
at the
is.
language and then look at your, listen to your comment at the same time. If that's
Very well.
possible.
Hold on, where is it the right one? Hold on. Is that the right one?
No, that was someone's email.
Sorry, I have so, oh yeah. Doing my best here. There we go. This one. Here we go.
Yeah, okay, so let's go back to 105C8.
Yeah, that'll take me a sec. But I'll get there.
I know it's a big draft.
Come on. Sorry, just moving things around my screen here. 105C8.
Yes, sir.
It's 105, I think it is. Oh, all right, 105. Here we go. Let's see.
And then go down to 8.
Here it is.
Okay, so let me get the chat window up. Query the records required. Yeah, and so it looks like we axed most of that section, but added in the except as otherwise provided in that section, which I think is fine. Mosin, do you have thoughts about that?
Well, we do lose something by not being explicit that the operating agreement can define appropriate remedies, including liquidated damages. That statutory language makes the availability of liquidated damages something that you can include in the operating agreement. In the absence of that, the availability of liquidated damages would be up to the court's discretion.
I guess it would be up to a determination of whether it was reasonable or not.
Right.
Yeah,
And-
with this language, yes. In the absence of this language, a court would have to do the kind of common law test for whether a breach justifies the remedy of liquidated damages.
Correct.
Maybe I guess it doesn't make much of a difference. You're going to get to the same place, and this issue is going to come up once in 1,000 years.
Just watch, you just jinxed it. It's gonna come up in every case from now to eternity.
I guess I'm going to give voice to the freedom of contract principles that underlie ROCA, and I believe we should maintain. I think what we've done to 105.8 goes too far in light of what we've done to 410. I mean, I think 410 is fairly expansive, but I think parties should have the freedom of contract to do what original ROCA contemplates here. And you know, it's not just the principle, but I think 105 gives drafters a bit of a checklist in terms of what they can do and cannot do. I think it's problematic when you have the marked up version of 105.8 and 410. I think there's some potential for traps for the unwary there. So I think we're straying a little too far from freedom of contract by ultimately when you look at the combination of 105.8 and 410.
And I was just looking at the comments to 105 C8 and what it's, and this is on page 30 of ROCA. It says, although phrased as a restriction, this provision grants substantial power to the operating agreement. And that's kind of consistent with what Michael was saying, the intent.
Well, if I understand correctly, everything that's in this struck language is in the language that Cody had proposed, other than the additional language that including liquidated damages for breach of any reasonable restriction on use. Because the language Cody had proposed does say that the operating agreement may impose reasonable restrictions on the use of information obtained under this section. Right, so we still have that. It's just not baked in here. It's baked into 410 or whatever the section was.
Well, I mean, a good point, Wilson, but I think you look at C8 in its original form, you have both of those concepts of availability and use. One is, can you get it? And two is, if you have it, are there restrictions on your use of it? So two very different concepts. And that combined with the fact that we've removed unreasonably restrict, and we basically say we can't vary the duties and rights under 410. I think, you know, correct me if I'm wrong, in terms of the availability concept, we've really taken away the party's freedom of contract to deal with the availability issue.
Well, I think the availability issue is also addressed in 410 with the language that Roberta was talking about with the just and reasonable. So, Michael, what would you suggest to address your concern? Because I don't think it's necessary to pull in the entire section that we've taken out in 8. And I think that if we add back in the unreasonably restrict, we get the unreasonably restrict or, you know, reasonably permit, right? This, you know, thing that Cody was noting earlier.
Again, my point is freedom of contract principles. I don't see what's wrong with the unreasonably restrict language in the context of 105 and what 105 is trying to do.
Yeah, I don't think it would make any difference. And so I'm not opposed to putting it back into 105. And I don't think it would make any difference because the language in 410 says that and I put it in the chat here, the language that Cody has drafted says the LLC may impose reasonable restrictions, although I guess it's the LLC and not the operating agreement of the LLC, which means the LLC can do it on an ad hoc basis. But just to continue, the LLC may impose reasonable restrictions on the use of Yeah, so you want availability in this, Michael?
somewhere.
Yeah, yeah,
I-
I think that's a fair
You
point.
know, if we go to 410 and may impose reasonable restrictions on the availability or use, I think you get that concept back that we're subtracting out of 105.
Okay, so if we go back to 410, Sandy, would you mind pulling that back up?
Just get the document back up. Yeah. Let me stop the share.
Michael, you persuaded me that I think we do need to deal with the availability issue. And whether that happens in 410 or 105, I think doesn't make a lot of difference. I think it's cleaner to happen in 105 because that's, as you said, where people will look to see kind of the checklist of what you can and cannot vary.
Yeah, but I think.
I agree with that. I mean, again, I think when we're teaching the bar about the Oregon's new act,
But it's
I
within
think
the
one of the
scope.
points are that you want to look at 105 as a drafting checklist.
Right, but I think 105 specifically refers to 410, and there's a lot in 410 that we aren't going to be able to shoehorn into 105.
And like I said, if the availability concept is dealt with somewhere, I mean, I'd probably feel more comfortable myself having it in 105, but I can live with it existing in 410.
Yeah,
Yep,
think
I
that's-
I digress a bit, but
Yeah,
why would we not, since we're trying to follow RCW, would we not want to consider, it looks like we tried to follow RCW originally. And they're 25.11508 G just says vary the records required under RCW blah blah, or unreasonably restrict the right to records or information under RCW blah blah.
sorry, Val, what section are we looking at? I want to make sure we're looking at the right thing. On 410.
You have to go down further, Sandy.
Thank you.
It's for that subsection 8.
Yeah,
8. Okay, there it is. Thank you.
so.
I
in the
think-
First line of subsection 8, add the limited liability company may impose reasonable restrictions on the availability or use.
Okay, so I want to make a broader point here.
Okay.
Which is what subsection 8 deals with is, and this language comes from the ROLCA language, and Cody and I had this back and forth about this being redundant. I take that back. It's not redundant. This is doing something different. What this language says is the LLC may, without any kind of language in the operating agreement, the LLC may do this thing. Whereas what we're dealing with in 105 is what the operating agreement can authorize the LLC to do. Okay. And so this language allows the LLC to do this thing, even if the operating agreement is completely silent on the matter. Whereas what 105 is saying is the LLC may place restrictions on the availability and use of records under this section. And if the operating agreement restrictions are reasonable, then they're enforceable. The LLC must do those things. The members are bound to those things. Do you follow that difference?
Yeah, I'm wondering if it's angels dancing on the head of a pin a little bit, though. Because there's a practical effect. I mean, I understand that what you're talking about is an authority difference, right?
I guess the difference would be, let me pull up the language.
I mean, for example, Mosin, if I'm trying to get information and the LLC is not giving me the information, and it's saying we have adopted some, rationale for why you don't get the information, and I'm trying to argue that that's unreasonable. Does it matter whether their rationale is based in language in the operating agreement versus some ad hoc decision?
Well, it matters in the following respect, Cody, that the way ROLCA is drafted, the operating agreement may include reasonable restrictions on availability and use. Okay, whereas the language here is just saying well, I guess the language here, is been drafted to be availability and use too.
Right, because we just added back in availability or.
Oh, okay, so that's not reflected in the red line. I got you.
Yeah.
Sorry.
Okay, all right, well then, I mean, I guess, yeah, Cody, maybe then we get to the same place.
And I think that having 8 here say availability or use also gets you to the same point as ROLCA. I mean RCW puts it, as well as what ROLCA says, with the difference being RCW says you can't vary the records required under section 410(1). And I think we would want to put that in there as well, consistent with the how Valerie always has the terminology for it, but sort of the legislature's decision about openness or transparency or something like that.
Yeah, I agree with that point, Cody. And with the addition of availability to the subsection 8, I'm fine with this language as drafted. I think it makes more sense in 105, but if it's here and 105 points to it, that's fine too.
Michael, did you-
Making a point about RCW, their version of 105, it's 2515.018 3G, vary the records required under RCW 2515.136.1, or unreasonably restrict the right to records or information under RCW 15.136.
Right.
I
think that second part of it is captured in the change we just made to our version of 8. The only, I think making this change that we're looking at on our screen here for 8, I think it mirrors and matches RCW, so long as what we would want to have 8 say then, or I mean 105C8 say is, I guess, vary the records required under 410(1), or the duties and rights under section 410 except as otherwise provided in that section. And then you would look at 410 to say, oh, how else does it allow there to be changes to the rights and duties? And you look at 8 and says, oh, I can do reasonable restrictions on availability and use.
Where have we landed with 8? Because
It's up on the screen.
I have fingers in too many places here, digital
Yeah,
fingers.
so
Well, there's 2 8s. There's 410.8 that we're looking at on the screen, and then there's
105
105C8.
oh, that's true. Yeah. So we added availability to 8C8 or to the 410.8, which is what's up on the screen. But we did not add it. We kept our language with 105C8. But I think this addresses the availability concern.
I think conceptually there's differences between 105 and 410. 105
No,
is
I
talking about
agree.
what can you do contractually.
I agree.
This sub 8 is really the LLC in the exercise of its discretion may impose reasonable restrictions. Well, I think that's something that is outside the operating agreement. Whereas, so it, frankly, I think the exercise of discretion could be challenged. Whereas if everyone's on board with the terms of what's in the operating agreement, I think that's a different analysis. So I think we're unduly restricting 105C8. And I think we should really take a look at the RCW version of that and maybe adapt it for what we're doing in 105. Because, I hear what you're saying. I just think there's different concepts here. One is contract and one is about the exercise of discretion.
No, I agree. That's what Mosen said, though. I mean, that was Mosen's point. But from a practical, if you want the records, what's going to happen perspective. I don't think
in the context of litigation, I don't know if I necessarily agree.
Well, what if we, after what if we like a little limited liability company, comma, whether in its operating agreement or otherwise, comma, may impose reasonable restrictions on the availability or use of the information.
You're saying
Doesn't
add
that take,
or 10
get rid
somewhere?
of the, doesn't that
Yeah.
resolve your concern?
Yeah, so in section 8, what Cody's saying is add, so it starts limited liability company, comma, in its operating agreement or otherwise, comma.
Is
Does
this,
that
you want,
address your concern, Michael?
Well, I think it closes that circle.
Okay.
I think from an editorial perspective, I think it makes more sense to have, you know, what RCW does in its version of 105. But, you know, if everyone thinks I'm off base there, then, you know, at least putting it in this sub 8 here in our 410, as you described, Valerie, I think it gets to the concept. I think it's again, when you look at the checklist potential for 105, it, you know, it gets you to the same place. Yes, it's
Right, 'cause 105
just
specifically references 410. So Sandy, can you go
So-
ahead and type that in, please?
yeah, sure thing. So,
No, not right there.
oh, sorry.
One more word over.
You want in 105? Sorry,
No, I
liability
want it-
company.
So add a comma after company.
Yeah,
In its operating agreement or otherwise, comma. Okay. How do we feel about that?
I think that that resolves the concern. I have my own concern, which is, you know, counter to complete freedom of contract, which is, for one, I think Oregon law does not allow this kind of any limitations on the availability of records other than what's set forth in the statute. You know, I don't think, for example, here looking at 2, you know, it talks about subsection 2 talks about an unfettered right to essentially get this information that's in subsection 1, you know, all those required records. You have that right to get that information. And it's not subject to a particularity or a connection to your interest. You know, you have certain rights. And, you know, really 2 talks about that. And then 3 talks about how you can get additional records if you jump over this, you know, particularity, et cetera, hurdle, and during regular business hours, you can get additional records. You know, 5 talks about, there's a lot of restrictions on how you can get records. And all of that is, you know, new. A lot of that, almost all of it is new compared to Oregon law right now, which doesn't allow the operating agreement to say, well, there's all these required records which we're supposed to give you upon request. But doing this changes that law in a way that now, you know, subject to whatever the court defines to be reasonable or not, the LLC can say, yeah, under 1, we have to keep all these records, but beyond that, you know, we're not going to give you things. We don't think it's reasonable what you're asking for. We've got all these reasonable, we think, restrictions on what you can do. And, you know, there's things about notice and all that stuff that's in the statute, but we're going to say, no, you know, we need, you know, 30 days notice instead of 10. We're not going to give you these we'll give you the records required to be kept under, you know, 1A through C, but not D through J.
Right.
So I think there's a
my
significant
thought about
transition
that-
away from transparency there.
Well, but it's not automatic, right? Because what you have here is you have people who are going into business together, agreeing to provisions or, you know, restrictions. So it's not as though the LLC is an entity divorced from its members, right? If that
No,
were the
that, I
case-
mean, that's certainly true. That, you know, that obviously goes to this overall question of how much freedom of contract do we give people.
right.
But I also, you know, I think the reality is that most LLC agreements are not carefully thought through with regard to issues like this. I think what happens is that people are grabbing forms off the internet, or you know, the transactional attorneys generally, I find, draft a sort of a default agreement, which is as protective and limiting whatever information would need to be given out. It would be maximum indemnification and reduction of fiduciary duties. Those, I think that'll be the standard form LLC operating agreement that your average customer comes in and gets without any thought to how that actually might impact their life down the line, or if they get into a dispute with their business partner who's cheating them, etc. And I'm not to say that people can't negotiate those kinds of clauses, and sometimes they do, but I think the mine run of LLC operating agreements are not negotiated with this kind of stuff. People assume that they're not going to get cheated by their business partner. So anyway, I just think we should walk that balance between we have our statutory terms, which is for, we've been talking about the carpet layer who doesn't even have an operating agreement. But I think that the more likely and more common situation, my guess, just based on sort of my experience and understanding, is probably 90% of the LLCs, they do have an operating agreement, but it's not thought through at all. It's just grab and go, and we're moving and we're creating the company, and now we're doing business and so forth. And so I think it is your carpet layer who has an operating agreement, and it's a question of what operating agreement does your carpet layer have.
I mean, I think that's a valid concern, and certainly summarizes the balance between, these two competing forces that sort of play out through the whole act, right? I mean, I do think that there is a greater emphasis in ROLCA than in the current statutes on freedom of contract. But I'm fine with the language that's on the screen before us now. And I just think that it's something that we're just gonna have to flag when we educate people and when we talk to clients.
I agree, Valerie. I think it strikes a reasonable balance. It's just something that I think the bar, the concepts here, the bar is going to need to be made aware of on the educational side of this process.
I think
Aurelia and David, you've been really quiet through this whole discussion. I just want to give you a chance to speak.
Well, I'm sort of in the Michael category, but I'm okay with the change that what we're looking at on the screen.
Aurelia?
Yeah, I mean, I share Cody's concerns about restricting the availability of records. I mean, what's sort of the point of requiring the maintenance of these specific records if folks can't get access to them? So I do share those concerns, and I think I guess I'm more inclined to go back to the RCW language than including the reasonable restrictions on availability here.
Okay, so let's put a pin in 410. Cody, can we go back and look at 105 C8?
Your Sandy, you mean?
Yeah.
Sorry. I keep calling it Cody.
Yeah,
I'm
it's
sorry.
no,
I'm
no.
looking at Cody as the problem, and then I do Sandy.
I'm always the problem. I will accept that responsibility. Give me. I found when you're dealing with students, especially, that's a good way to start. You just kind of never mind. All right, here we go.
Okay, so 105 C8. So Cody and Aurelia, if we were to add back in, as opposed the unreasonably restrict at the start of section 8, as opposed to vary, would that address your concern?
Well, so my concern is that opening up restrictions on availability of information beyond what I think already are, for a lot of types of information, pretty, strict. I mean, ROLCA creates, in terms of availability, and our modified ROLCA and our current Oregon statute says you can't make any of these changes. These are the records, and here's how you get them. And certain things you have an automatic right to, and other things you can request. And our version of 410 maintains that dichotomy. Certain records, automatic right to; other records, you have to jump through some hoops. I think that we ought to just stick with that and not allow additional hurdles to be imposed on access, the availability of the information. That's what I think ought to be the case. If we are going to go, and at least the the tenor of the group that we have here seems to be wanting to change that and allow the reasonable restrictions on availability of information. If we are doing that, then I think what I'm looking at on the screen for 105C8 would be fine, but we would want to, I think, following the RCW, change 410A to at the beginning say that you cannot vary the records required under 410.1, but you may then impose the reasonable restrictions. That is what I would suggest to do that. But again, my preference, and I think Aurelia, as I understood her, would be to basically to not have the freedom of contract here as to availability of information and only have it as to use of information.
Okay, so I guess then we should probably take a poll on how the group feels about this. Since I think this is come down to a philosophical difference.
I'm going to stop. I'm going to stop the share for a sec. Oh, David, please.
What would be a restriction that one would envision for a restriction on the availability of a record?
Go ahead.
No, go ahead. I just asked my question. So.
Well, so for example, 410 says all those records in subsection 1, the required records that they have to be kept, and the member need not have any particular purpose for seeking those records. Well, a restriction an LLC might adopt is, well, if you want any of those required records, you have to jump through the hoops in section 4. You have to, ask for particularity. You have to show that you have a member-related interest, and this request has to be connected to that interest. That's one example. So rather than being able to get that information, for free, now we're going to impose restrictions on it, or the cost. We're going to charge you more than the reasonable cost of charging it, of copying it. We're going to, charge you, attorney fee rates to obtain this give you this information.
I don't think that's an issue, because I think we've got the restriction on photocopying costs or duplication.
No, that restriction's in the statute. If you allow the operating agreement or the LLC to impose reasonable restrictions beyond what the statute says, then you can charge whatever a court would deem reasonable. It's, the statute goes out the window and you do what you want in the operating agreement. You can completely rewrite this section. So, 2 talks are about, that's just a few examples. Right now you have a right to obtain records during regular business hours. Well, the LLC may end up saying you can only get the documents between noon and 1 over the lunch hour. You can, the 10-day period maybe is a 30-day or a 60-day period before you can get records. Those are just some examples of, ultimately, I think it's whatever David and Michael or, whoever is creating these form LLC agreements ends up putting in them. Whatever becomes the thing that lawyers start putting in operating agreements, that will become the restriction on availability, and it just overwrites all of these statutory rights to information. A little bit like under 2B, the LLC shall furnish to each member without demand any information concerning the company's activities, affairs, financial condition, and other circumstances which the company knows and is material to the proper exercise of the member's rights and duties. Or for example, 2D, whenever there's going to be a vote, before the vote, the company shall, without demand, provide the member with all information that is known to the company and is material to the member's decision. Well, if we allow all kinds of, restrictions on use subject only to whatever a court might deem reasonable or not, it might be that the LLC says, no, you've got to make a demand, you've got to make it, 30 days before our meeting. And if you don't do that, then we don't have to give you the information. It might be that we're only going to give you some information, or the information that we think should be material to your determination, to your vote, member. I'm just coming up with ideas.
Yeah, I mean,
And
I think we're sort of thinking of
I'm
the
easily
apocalyptic
seeing myself
scenario.
litigating all these issues in court.
Sandy, is there a way to get both sections up at the same time?
Probably. Give me a second.
You could do a screen share of your desktop with both documents.
Yeah, that's a good call. Give me 1 second. I've honestly, I probably have 50 windows open, so I'm gonna need a second, but I'll get there. Finals are a crazy time. But I am manipulating documents as we speak.
You just think that you're gonna get more.
Okay, hold on. I'm just trying to, I gotta shrink some things here. Sorry, I'm gonna stop sharing for a second because it'll let me actually
Probably
do
a good
this.
idea.
I just can't.
You know, and I would point out that ORS 623-771 is how you would get records now. And there's still a subject to the reasonable request at the expense of any member during business hours, on sub 2 in that section. So
I'm almost there on this. Hold on.
Right, but 771 and 777, there is no, the operating agreement can modify this. And the way that ORS is currently structured, if they're allowing the operating agreement or the LLC, otherwise to modify your statutory right, it says, unless otherwise provided in the operating agreement, which it doesn't do in 771 or 777.
All right, are you all seeing both documents?
yep.
Yep.
So can you scroll down to the language we were talking about, Sandy? And
On 410,
Yeah, what section? I apologize.
8.
Just 8, thank you. Here we go.
I mean, in general, I think 410, as we're looking at it, has robust protections for the LLC to, ward off unreasonable requests for information.
I think I'm fine with the combination of the two. It's a little different than the ROCA approach or the RCW approach. But nevertheless, 105C8 still is on the checklist and requires the drafter to go over to 410 and study that if they're desiring to have a provision that deals with particular issues to determine what you can and can't do inside the operating agreement. So I think what we added there, in my mind, closes the circle. It certainly makes this whole issue much more complex than under existing law, but it is what it is. I think it's probably closer to dealing with real world situations than our current statute currently avails.
Cody, I think I would be more concerned about the 410C8 language if there wasn't that last sentence where the burden of proof is on the company to demonstrate reasonableness, if there's a dispute about this.
Yeah, I hear that. I mean, to me, I still am concerned that, well, I have two thoughts. One is I still would prefer to get rid of the words availability or from 410.8. Secondly, regardless of whether we do that or not, I think we ought to, in 8, include the fact that the LLC cannot vary the records required under section 410.1, which is in the RCW. And I think, I want to say that maybe there's an Oregon, I want to say that even one of the Oregon statutes that we put into ROCA requires like the Secretary of State to be able to get those records. Even if, the LLC were to bar its members from getting those records.
I think trying to restrict the 410.1 records would be by definition unreasonable. I don't think, I can't see as a judge concluding otherwise, regardless of what the operating agreement says.
Because they're pretty, it's a pretty basic list of documents.
It
Go back
is,
and
it
look at
really is. And I think it would be silly for someone to try to draft away from the sub 1 list.
That may be, but
So
I
I think we should say in the statute, like Cody has suggested.
yeah, if we're all in agreement that that should not be able to be changed, we should just say so.
Okay, so what language would you suggest?
I would say, so on 410.8, the limited liability company, leave that, but then I would say may not, without the, before the comma,
Before the
may
comma.
not vary the records required under subsection 1 of this section. But may, or maybe get rid of the may there. Yeah, but. No, keep the but. Yeah, there.
Oh.
Sorry. There.
Yeah, I think that's reasonable. Michael, David?
Like to hear what David would think. Like I said, I think it would be silly for someone to try to restrict the,
Right.
the subsection 1 list. So this doesn't really give me much heartburn. I'd like to hear what David thinks.
I have the same opinion. I think the subsection 1 documents should just automatically be given over. So.
Yeah.
Well, and again, in terms of automatically being given over, that's different from varying the list of the records that must be kept at the office. What
Right,
we're
but
looking
I-
at
Again, Cody, I don't want to go down that road again. I think we've already sort of beaten that horse to death.
no, I just meant that I understood David to say that, yeah, it's a gimme that a company would have to give you those records. I'm just pointing out that it's not having the, and I understand that this group here has decided to have the availability language in 410.8, but I'm just pointing out so that we're all clear that takes away the automatic right to get those records under 410.1.
Right,
And it
but I think-
subjects it to the reasonable restriction of the LLC.
But I think what you're hearing from the transactional folks is that it's sort of a prima facie unreasonable that they wouldn't give over the short list up there of the sort of basic entity documents.
Like articles of organization.
Yeah,
Do we add a comment to that effect?
I would be okay with that.
Sure. Do you want the comment in 410 or in 105?
No, 410.
But hold up.
Oh.
David, Michael, I didn't hear either of you say that you oppose just saying that in the statute. Do you oppose saying that in the statute, which is what Cody is proposing?
Opposing what we just added to 8? Is that your question?
No, adding in a statute that you cannot, what's subsection 1 says is you have to keep this list of documents. And what Cody's proposing is that the statute says, and you can't opt out of that. You can't vary that list of documents.
Right?
Would you oppose saying that explicitly in the statute, that you can't opt out of keeping these documents?
Isn't that what we just added to sub 8?
Yeah,
I think it is. I think the question would be whether to put in the statute that you can't vary the member's right under subsection 2A.
Okay, got it. Yes.
I think that's what Mosen's saying.
No. I was relitigating something we've already resolved then. Sorry. I
Okay.
take back my comment.
Okay, so can you please scroll down then to the comments, Sandy?
Yes.
Okay, so after that comment, we added about 13, or maybe before the comment, we added about 13, sorry.
No problem.
So add a comment to the effect that 8, it is the committee's opinion that the access restrictions in section 8 would be silly to apply to the items in section 1 or something like that. Does that sound
Sure.
reasonable? There's probably a
would
more
be-
lawyerly way to say that, but
So yeah, if someone help me with the language, I appreciate it. That the access restrictions section 8 should apply. Is that
no,
what
it would,
no.
It's
that-
not a-
Be
No, it-
unreasonable.
sorry. Did somebody say something?
Would be unreasonable to restrict the availability of the records in subsection 1.
Yeah. So it's the work group's opinion that the access restrictions in section 8 would be unreasonable.
Or if applied to
Yeah,
the
to
records in
documents in
subsection 1.
Yeah. Michael, David, any thoughts on that?
I think that's consistent with what we were talking about.
Agreed.
Cody, does that address your concern?
Yeah.
Okay, so why don't we call this done unless anybody else has anything else they want to say? Sandy, if you could please insert section 410 as a substitute for Roll Call 410 along with the comments that we've discussed.
Will do.
And then let's take a 10-minute break because I'm out of coffee. Okay, so I'll see you back at 10:35. Okay, section 8. I have lots and lots of handwritten notes all over this section.
And FYI, Valerie, this is the only meeting the entire time that we met where I missed a section of it. So I am relying, people have done, I think you probably can't win and did work in the document on this.
Well, I think Cody did as well.
or
I
Cody
don't
did.
have any.
Oh, I haven't touched the document on this.
Okay.
I forgot
Somebody
what-
did.
Okay. I forgot what we were here to discuss today other than 410. So I didn't mess in the document.
Anyway,
at all.
someone has graciously gone in and done a good amount of work on 8. So it is updated.
Yeah, so I don't actually have any changes to language on 801. It's pretty straightforward from my perspective.
So someone had highlighted the section B.
Well, B is I mean, maybe I did this a year ago or
that
something.
may have been, yeah.
And don't remember it, but I certainly haven't done it in the last 6 months. But 801B is something that this was one of our political footballs because
Yeah.
801B restricts the ability to bring a direct action. It poses additional restriction compared to current Oregon law. In particular, and this is something where Kyle and Aurelia and I had we did section 8, and a lot of what we talked about for article 8 the group all agreed on, but there were a few issues that we had not agreed on, and this was one where basically the defense bar was going to look at it and think about it. So we had proposed modifying this to say that a member maintaining a direct action under this section must plead and prove, and then either an actual or threatened injury that is distinct from an injury suffered or threatened to be suffered by the limited liability company, and then add, or a breach of a contractual, fiduciary, or other special duty owed by the defendant to the member. That is what we had
Oh yeah, now that I look at my
talked
handwritten
about.
notes, that's what I've got as well.
Cody, could you put that in the chat and I can add that in?
Yes.
Thank you.
Because isn't that
That's
the
something the group has
protest?
previously approved.
No, it is not. No. This was something that I don't know if I originated the phrase, but we had called them political footballs. I think maybe Valerie had originated that phrase here, but it was something that the group had not made a decision. There was no decision made one way or the other. It was there was disagreement, and then there was decided to punt the issue.
Pretty extensive comment under subsection B from the ROCA drafters here. I didn't realize this was going to be another extensive issue, or else I probably would have studied this comment more in depth. I mean, very extensive comment.
Yeah, and so we've got, longstanding Oregon law, a lot of common law. You're not, maybe not common law, but common law with a layer of LLC related to it. So Oregon law provides a disjunctive test for direct actions. And this, I'm quoting Wolf against Mackey from 1995. Minority shareholders may bring direct rather than derivative actions if they allege either harm to themselves distinct from the harm to the corporation, or a breach of a special duty owed by the defendant to the shareholders. And then, other cases say, these are all Oregon appellate cases, a special injury is established where there is a wrong suffered by the shareholder, not suffered by all shareholders generally, or where the wrong involves the contractual right of the shareholders, such as the right to vote. And then other cases similarly discuss the difference between direct and derivative claims along these same lines, including in the LLC context, I believe.
Okay, I guess I would have to look at those cases to reach my own conclusion on it. I'm just reading the comment that says this subsection codifies the rule of standing that predominates in entity law. Again, going back to the original purpose of looking at a uniform act is to try to make Oregon, at least somewhat uniform with other ROCA adopting states. Maybe we need to send the case citations out to the group. I wasn't aware that this was coming up with a substantial change.
Cody, so if I understand this language, you suggest it codifies existing Oregon common law. If that's the case, why can't this second part be covered in a derivative action? What makes a derivative action insufficient? Because what is in ROCA to me is what is required to be a direct action. If you don't meet the test that's in ROCA, then what you have is a derivative action. And the idea is that you still have an action, it's just a derivative action and not a direct action. Why wouldn't that be sufficient?
Well, a derivative action is when you're suing for something that is a result of harm to the company, really, and then you're only harmed essentially because you own the company. You don't suffer your own injury, and that's part of the phrasing of the test here is there's not solely the result of an injury suffered or threatened to be suffered by the LLC. But in particular, that solely language changes the test. And when we had discussed Article 8 before, I think we had talked about how Delaware has abandoned the special injury test. Like I quoted the Oregon test, how there's this disjunctive test. There's two paths to a direct action, and one of them being language along the lines of what you're seeing there in 801B. But the other path being the special injury test, which Delaware has abandoned. There's a law review article talking about cases where direct claims were upheld based on special injury, that direct claims would likely have come out, the cases likely would not have allowed the direct claims to be brought without the special injury test. And either it would have funneled them through derivative action or denied recovery altogether just out of the gate. And so I think this is an important change to, this is kind of the kind of claims that I bring, direct actions as well as derivative actions. And I think this is a significant change, and I don't think we should follow Delaware law on this. And at least, that was the recommendation of Kyle and Aurelia and me, is to allow this special injury test that Oregon has to continue.
David, do you have any thoughts on this?
So this is completely out of my wheelhouse. So, Cody, is Oregon law on direct action, is that at least as it relates to corporation, is it different than most states, or are we an aberration, or is it consistent with other states?
I think that there are other states that have this special injury rule. I mean, Delaware used to have it and relatively recently got rid of the special injury rule, the separate path to being able to maintain a direct action, but not all states have followed suit. And for example, Oregon hasn't.
So I guess we are somewhat of an aberration then.
Well, I don't know if we're part of a minority or whether we're alone or what have you. But
Wilson looks like he has something he wants to say.
go ahead.
Yeah, I just was going to add the additional data point that with respect to this issue, the RCW omitted this section altogether, essentially punting to the common law the distinction between a direct and derivative action. All it says is that you can bring a derivative action if you make demand or show demand futility, but it doesn't tell us as a statutory matter when an action is direct or derivative, punting it essentially to the common law. Maybe that's a better way of doing what Cody's proposing here, because it would essentially do what Cody's proposing, but rather than codifying the common law, it would allow the common law to evolve as the courts see fit.
That makes sense. And California also did not adopt this. 801B also was not adopted by Alabama, Arizona, Illinois, or South Dakota. Florida modified it to say something very similar to what Kyle and Aurelia and I had proposed, which was an actual or threatened injury resulting from a violation of a separate statutory or contractual duty owed by the alleged wrongdoer to the member, even if the injury is in whole or in part the same as the injury suffered or threatened to be suffered by the company. So I think just not adopting 801B would be one potential way to resolve this.
And just to clarify, RCW didn't adopt 801 in total. It has neither 801A or B as far as I can tell.
Exactly. And California is the same.
Well, I don't know what to do.
Well, so what you are recommending then is perhaps deleting B? of
Well,
801?
I think deleting B would work.
I would delete the whole thing if we're going to do that.
I think that works as well. I mean, current Oregon law doesn't have a statute on direct
Direct
actions.
action.
There's
Right.
only a statute on derivative actions.
Yeah. So what this provision essentially does, 801 says two things. Members can have direct actions, and these are the circumstances under which they can have direct actions. We could just, and to the extent none of that's codified in Oregon law, we could just defer to existing Oregon common law on the matter, just omit 801 altogether. Not being familiar with the common law, I don't know how much I like it or dislike it, so I have no opinion on the matter, but that's what it would do if we just omitted the whole thing.
Michael, you look like you have something to say.
I guess I'm gravitating towards where Mosen is, that, where we've not had a direct action statute, and the legislature, can we infer, hard to say, but can we infer that they saw the development of Oregon common law and chose to not legislate in this area? I mean, you can make probably a somewhat weak inference that that's Oregon policy. So I think you could delete 801 and make a commentary as to why we did that. I mean, I think if we delete it, we have to have a commentary that explains our decision.
Right. So Sandy, go ahead and line through 801.
Yep.
One final data point, you probably are all already aware of this, but not me. That ORS chapter 60 also has no similar codified rule distinguishing direct and derivative actions. So this would be consistent with what we have in the private corporations chapter.
So, yeah, okay.
Be curious to
and-
know whether the revised Model Business Corporation Act has this sort of distinction.
I'll take a look now, David. I'll follow up in a second.
So the commentary then would be the intent is to make it consistent with existing Oregon law and direct questions with respect to a direct action back to the common law. Does that sound reasonable?
I think so.
Okay.
Okay.
802 was one that we left.
Yeah, I have 802,
Alone?
803.
Yeah.
And 804 are
I have
as
not-
ones we left alone.
Yeah, I have
That's
nothing. I have nothing either.
And then 805, I have a big pink X through.
Yeah,
Yeah.
we cut.
We cut A, it looks like. Oh no, we cut
No, the whole
all
thing.
of it. We had the whole
All of it.
thing. Yeah, I have
Yeah.
that too.
And then what is that stuff at the top though, Sandy?
I did not insert. that.
Oh, well, so what we had done was take some language from ORS and make that be 805.
Oh, the state pending investigation. Cody, I see the title.
The title and then the content there, that's
Yeah,
all
I
in
see it.
purple.
Okay.
I wonder if this was James's edition because I think he raised a bunch of questions in this area. Yeah.
Because I had the same thing that was all deleted except for that.
Yeah, okay. That's from 63-801 sub 2, I think. That's what I've got in my notes.
Can I just, I'm sorry, Sandy, can you just scroll up
Oh,
so I can read that
Sure
paragraph?
thing. Sure. 63-801 sub 2.
Okay, good, thank you.
And then I'm going to do a comment, Valerie, at the end. It says the new section is from, the new language is from 63-801 sub 2.
Did they change it? They may have changed. No, Sandy, go back up to that language, please.
Got it.
Derivative action, whether or not a demand is made under 802. That's the investigation. No, that's not.
Yeah, it's the second sentence of ORS 63-801 too.
A very long paragraph. Okay, yeah, there it is. Okay, so go back to the comment then, Sandy, please.
Sure thing. Hold on. Oh, I just went too fast.
Yeah.
Here it is. Got it.
Okay. Second, and then add second sentence.
Got it.
Okay. Anything else on 805?
What's the title of that section?
Currently, it says stay pending investigation.
Great, thank you.
806, I have a ton of notes on.
Yeah.
But I don't know where we ended up because I have a note saying that James and Cliff were going to talk to lobbyists, and I don't know that that ever happened.
So the thing that was up for discussion was section B there with the reference to reasonable expenses, including attorney fees and costs, whether that includes expert witness fees. That was the question. And
Yeah, I have that note in there.
and you know, we had recommended adding after attorney's fees specific reference to expert fees just to make it be clear, in part because under current Oregon common law, there's the thing called the common fund doctrine, which is an exception to the American rule that you don't recover attorney fees, and so you can get attorney fees. So but we think it also gives you expert fees. So unless this says that you get your expert fees, we think that it's potentially a change in current Oregon law. But it also, Oregon law has a lot of language that if you just are talking about, you know, costs, or you just talk about sort of expenses, they assume you mean the things that are covered by ORCP 68, which doesn't include expert costs.
I mean, I have no opinion on this because it's so far outside of what I do.
I'm confused whether we're making a change to existing Oregon law or keeping it the same.
So if we add expert witness expenses, is that changing the law, Cody?
No, you know, strike that, you know, no, sorry, I'm looking at my notes again and rereading them. I think we're fine just leaving ROLCA as is. Aurelia, what do you think?
Yeah, I remember a discussion about this. I think we went back and forth about whether existing Oregon law using this phrasing would include expert fees. And so I thought we were leaning towards just adding the expert fees language in to ensure that that's clear. I don't think
weren't we unsure whether that's a change in Oregon law or not?
I did not think it was a change to Oregon law, that those kinds of fees were recoverable under the common fund doctrine.
Well, then why don't we keep it as is?
Yeah, and just maybe make a, well, we don't have this statute in Oregon now. It's available under the common law. And so putting it in the statute here where we don't actually have a statute on that right now in Oregon, you know, I can see a court saying, oh, well, now you've codified what's available and you've codified attorney fees and costs and expenses, but we're going to interpret expenses and costs to only be the things because courts in Oregon often will do similar things. It's not clear whether they would say, nope, this is changing that and now you don't get expert fees anymore.
I think addressing that in a comment would be appropriate.
That the recoverable expenses include expert fees?
Well, it's you know, in the context of what's available under existing Oregon law or as the common law or rules of procedure or other statutes come into play.
Yeah, I think that's a good point. That this statute is not intended to change Oregon law on recoverability of expert witness fees.
Yeah, it just seems like we're out in front of our skis if we go a lot further without and just say look to other places, court and litigants.
Yeah. So Sandy, the comment is the list in section B is not intended to change current Oregon law with respect to recoverability of expert witness fees.
I think that's a good way to resolve it.
Okay. Yeah, and then in C, I do have that language that we added there.
gonna make it red just to make it clear.
Yeah. And then
I'm
807.
gonna, oops, sorry, apologize. I was gonna take the highlight off this just to make sure we know
Yeah.
what we talked about it.
807, I do have a note that we were adding something here.
Yes, this is new section 807,
That's
Yeah.
right.
which is incorporating 60.952 sub 6. Because current Oregon corporate law this is the Steve NATO
Yeah.
statute.
This was going to ask, this is the NATO provision, right?
Yes, exactly. And so this is in our corporate law, but it's not in ORS chapter 63 right now. And in my experience, you would think, oh, well, you can, make the argument that this statute doesn't apply in LLC cases, but I think courts will often apply it in LLC. And I think parties will treat it as applicable to LLCs right now anyway. And frankly, I don't know. I think it's a fair procedure. You get, you get bought out, and that's it. That ends it, and the LLC can move on.
I think it's a good addition.
I do too, actually.
So we should,
Yep. So just, yeah.
let's make a comment, definitely.
But yeah, comment as to where we got it.
So it comes, it's 60, it's ORS 6952 sub 6, is that correct?
952 sub 6.
Perfect. And it's analogous to it? Is that how we want to say it?
No, it's essential. I want to say it's like, there's some changes to make, like, it'll reference certain things that aren't here because it's, subsection 6 of it.
This new section isn't intended to incorporate the language and process from ORS 6952 sub 6.
Yeah, I mean, I think it's basically the same, but there's just some, different references where it references
Right.
something else.
But identical in substance, is that a fair statement?
I believe so.
Yeah.
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 Besides,
Can
it makes me giggle to add the word incorporate into the LLC Act.
Oh, I'll get rid of that. Sorry. I was
Should
just
we
gonna make
say
it red.
form instead?
No, I like it.
Organize. It's
Any
intended-
any
organize.
opportunity to insert bad law puns, I think we should seize today.
Sorry, it's gonna make it the right color. Okay, and I'm gonna make all this red, but I can do that later.
Okay, look at this. Section 9, Article 9.
Oh, well, before we get there, I
Ah.
think that we need to cover the portions of 105C that are affected, that are relevant to this.
Dude, you're killing me. Okay.
Well,
That's okay, I can get back up to 105.
the easy part is that, well, I'll wait till you get there.
It's just gonna be a minute. Sorry, these shared documents take a lot of scroll.
It's fine.
Thank you for your patience. There we go. Okay. I'm in
So
105.
the first thing we can talk about is 105C12.
Now we're in the commentary.
Yep, now I see that. 105C12 right here, which is
Yeah,
crossed
so
out.
we had agreed to cut that. I just want to make sure everyone
Mhm.
sees that. And then on 11, we had not had agreement on what to do about 11.
Yeah, and that's why it's highlighted. Yeah.
I want to give me a second here as I think what I have there is what Kyle and Aurelia and I had recommended that we do.
I don't understand the punctuation in that last highlighted yellow line. Go back and
This-
just, so
Oh,
it
it just go back and discuss related to 8 to section 8 sub 2 is what I meant to write.
but there's a parenthesis at the front of that line, and there's a parenthesis between the 8 and the 2, which is confusing to me.
It is, that was definitely an error on my part.
So what should it be?
I think it was just a note for us to do what we're doing right now. So I can just delete, I can just get rid of it.
Yeah, I think we can delete that little.
Yeah.
That would be good. That will
Great,
Fine.
happy to do it.
anything that we can do to avoid confusion
And it's gone.
and add puns.
Yep.
I think that's fine. Anybody not think that's fine?
So RCW puts in the word unreasonably.
Looks like we took out unreasonably there. So this is the things the operating agreement may not do, correct?
Right.
So
Can-
I don't have a problem with unreasonably. Does anybody else have a problem with unreasonably there?
Well, here again, Oregon law doesn't allow the operating agreement to place any, I mean, in general, it doesn't authorize the operating agreement to place restrictions on your ability to bring a derivative action, which is now all that Article 8 is covering. So this specifies additional flexibility that a company would have, in express language of the statute compared to current Oregon law. But for example, some of the things that the statute is talking about here with regard to the, demand that needs to be given before you can file a derivative action, and the requirement of pleading your case with particularity and so forth. The question is can you put additional restrictions on that beyond what the statute is providing for?
I'm concerned about striking unreasonably the implications you get from that deletion. Does it license one to be unreasonable? Whereas I just think that, I'm not bothered by unreasonably there. I mean, that reasonable, unreasonably restrict, it's imposing an objective standard here. And I think it's a mistake to strike that and potentially pull us away from an objective standard.
Right. Well, so the way that this is drafted, and it would only be, the proposal is only the yellow highlighted language that starts with the word restrict. It wouldn't include any of the sort of the black and white language that you're seeing there on the first
Right,
line of
it's looking
section
at
11.
right.
And by getting rid of the word unreasonably, the point is that you can't restrict at all. You can't even do a reasonable restriction on the right to maintain an action under Article 8, except for you can do these 4 specified things. Whereas if you add the word unreasonably, then you are authorizing additional changes to the right to bring an action.
So, okay, that's what Sandy just did, clarified what we're doing here.
Yeah, because
Thought we
it's
were
duplicative.
keeping what was just stricken. Sorry
No,
for the
because it's,
confusion.
Michael, that's duplicative. If you read the restrict the right of a member, so that portion is already in the next section, and then what they've done is add the accept that language. But the question is, should the word unreasonably be in there?
I follow. I guess the question is someone without unreasonably, is someone still held to an objective standard, or do they have license to be unreasonable?
Well, it doesn't give them license to be unreasonable in their restrictions because it doesn't give them license to make restrictions at all,
Right.
except for these 4 authorized restrictions.
And
Could
these
those-
deal with derivative actions. I mean, they don't deal with any other,
Right, because we have gotten rid of section
Sure.
801.
yeah.
And therefore, there's no Article 8, in terms of the right of a member to maintain an action under Article 8, Article 8 is now only discussing derivative actions. So you know, this doesn't authorize any change as to direct actions.
So another question is like, and again, I'm outside of my wheelhouse, but could you actually impose in your operating agreement, imposing one of these 4 items, all of these 4 items in a manner that's unreasonable, for example, and like the forum, for example, here we're in Oregon, but you say, oh, you have to file back in Pennsylvania.
Right. So maybe it would, yeah, that's a good point. Maybe it makes sense before A there, you know, so except that the operating agreement may require, comma, if reasonable, A, pre-suit mediation, etc. That would preclude the ability to have an unreasonable mediation or forum or something like that.
So with respect to forum and arbitration, that's gonna, I mean, with respect to forum, I think that's unnecessary because the common law already deals with forum selection provisions that are gonna impose undue burden or hardship on a party. With respect to arbitration, that's just flatly preempted by the FAA.
To the degree the FAA applies to a case, you know, to agree that it's maybe if it's a multi-state company, but I don't think we need to add the word unreasonable. I think I agree with your ultimate point that
Yeah.
we don't need to add reasonableness.
I would get there as well. I think, you know, we're dealing with the operating agreement. There's an implied covenant of good faith and fair dealing that's embedded there. I think that gets us there without monkeying it with it anymore.
I guess I'm okay with it too, but I have had a couple situations like in the employment context where the poor employee lives here in Oregon, but the company say is I think in my case was a Michigan case. So any case he brought, he would have to go to Michigan to do it. But I don't know what it really impacts what we're talking about here because we're talking about a derivative action.
Right.
Right.
Right. And now that I'm thinking about it, I have a question, which is with regard to direct actions, the default of ROLCA is that you can modify anything unless 105C says you cannot modify it. And I wonder whether now that we've deleted 801, whether we effectively are allowing any modification, you know, therefore we're allowing all modifications to be made to direct actions.
I mean, I think that's consistent with where we are right now, though, right?
No, that's not where we are right now. They can't do that.
I think basically current ORS has the freedom of contract principles. So I don't see that as a change in existing Oregon law.
So Cody, your concern is that now that we've eliminated the provision that expressly codifies direct actions, the common law right to a direct action could be modified by the operating agreement?
That's right. With no guardrail.
That's really forward thinking in some sense. I don't know whether I would put in the operating agreement anything about a direct action, but
Maybe we would have this C11 say restrict the right of a member to maintain a direct action or an action under Article 8.
So
I
Cody, as we
I
think,
don't
Sorry, go
necessarily
ahead.
agree with that because I think I'm with Michael on this one that, you know, you do have some freedom of contract principles that are implicated there.
so Cody, if we think about the kinds of claims that we brought as a direct action, they include claims for breach of contract and breach of fiduciary duty owed to a member. And maybe there are others, but I think that covers a lot of them. And with respect to a breach of fiduciary duty claim being brought in a direct action, if the operating agreement attempts to limit in any unreasonable way a member's ability to bring a direct action for breach of fiduciary duty, that seems that would run afoul of the provisions in 105 that limit the waivability or restrictions on fiduciary obligation.
Right. I mean, 105 and the whatever article talks about what your fiduciary duties are, for example, that defines what the duties are or are not. And then you bring a claim based on violation of those duties, however they are defined in the operating agreement or in the statute. And then the question though is, can you alter the process, for example, of the ability to bring a claim beyond just the definition of whether the duty was breached, however the duty is defined?
Yeah, that's slightly different. Yeah, that's a good question. I guess the existing LLC statute here doesn't say one way or the other whether you can limit one's ability in the operating agreement to bring a direct claim, does it?
I don't think it says one way or the other.
Right, which is why I think that where we are in the current, as drafted currently, reflects the current ORSs. I mean, I think we could put a comment saying, you know, or a note saying that this is intended to comply with the current.
I think that's fair, that we're not intending any change in Oregon law with regard to
Right.
direct actions here.
Right, and so not there, Sandy, but down
At
in
the end of, yeah.
yeah.
This, I gotta,
What is all this?
this is, I gotta delete that. We've already gone through it. Sorry. It would go right here.
Okay.
So that is, so it's section,
105.11.
so
Or
it's
105.
section, it's section 11, because this is part 105.
It's C11.
See, okay. Oh, it always does the copyright thing. Sorry.
I just want you to know that the page that I have here is completely falling apart because we've been on this
Yeah,
section so much.
so section 311 is not intended.
No, 105.
Right.
Yeah, 105 C11. Yeah,
To,
change existing Oregon law.
thank you. I spelled existing wrong. I did.
It's hard to type with an audience.
I'm getting used to it. All right.
Anything else in 105?
I'm gonna move down to 9 unless someone stops me.
Sounds good.
Let's roll.
Here we go. There we go.
Yeah, I have 901. We did not make changes to.
Agreed.
902. I have us adding language from 63,704, 2, 3, and 4. Yep, 2, 3, and 4. Anything else in 902?
Yeah, I guess so. We're added that, all that stuff is the language from 704, 2, 3, and 4.
Yeah.
Okay.
Right.
And I put the notation to that
Yeah.
in the commentary as well.
Okay.
Except I spelled that word horribly.
And then I don't have any other changes to 902.
Amy still with us? Just, I mean, we're playing a lot in Secretary of State land here.
Well, we have Kevin here and Jamie, so. Hi, Jamie.
Hello. I am catching up, but I believe that I don't have any notes of anything else we wanted to change.
Okay,
And then
thanks,
903
Amy.
foreign registration statement, which is the 63,707 parallel.
Yeah.
I thought we had in 903 1 or
Something about
yeah,
naming
903 1. I
convention.
thought we were cutting everything after the name of the company.
I don't have that deleted in mine.
I didn't either.
Didn't either on mine.
Alternate name.
Yeah.
What did we do with 906? Hold on.
906. Sorry, do you want me to scroll to that?
No, I'm just looking at my notes.
Well,
We got rid of the alternate name language, I think.
I thought that, I mean, if, when we look at 906, we axed the ability to have an alternate
Right,
name, I
that's what I
thought.
have as well.
And if we're
So
doing that, then I think we need to modify 903 sub 1.
I think
Mhm.
you're right. Yeah, because I looking at my notes in 906A, we got rid of the alternate name stuff.
So should I delete after,
Name of the company.
got it, after name, just after name of the company, got it.
Everybody else okay with that?
So, yeah, sorry. And then with 63707, we were just going to tack on here.
Yeah, I have that at 637072 A and B.
Just
Yeah.
2A and B? Okay, hold on. So I'm getting rid of all, we're just 2A and B, correct?
Well, I thought we were not. Well, I thought we were going to add
Oh.
63707 1 C, D, and H.
Yeah, I think probably the note here in the commentary or the note for Sean is to just synthesize, add an E after language.
Yeah. Saw that.
Yeah, yeah, I think that's an accurate statement because I have different notes here, but I think really what Sean needs to do is just synthesize the two.
Is the way it's written okay, or do you want me to write what you just said?
I think that's fine.
Okay.
Add a parenthesis after G, the quote after G, please.
After, got it, see it, thank you.
Does that sound like a reasonable approach? Because Sean's gonna want to finesse the language anyhow.
707 except G. Well, yeah, I mean, my notes had said that we should add, yeah, but like add 707 1 C, D, and H, and add 707 2. So at least my notes say that it wasn't only G that we were axing.
Oh,
Well, I mean, it's basically synthesizing that though, right? Because A is the name of the foreign limited liability company. And then B is the name of the where it is,
Okay.
which I think is what we have in 1 and 3 of 903.
Uh-huh.
And then, yeah. So I think that the comment as written is fine. And we can see what Sean comes up with as a result of this too.
We do an explicit call out to legislative council here, like we've done in some other places where
That's-
we're expecting them to do that.
yeah,
Sure.
I'll do that.
So under consensus, no, what did you
Oh, I
have?
was just making it red, but yeah,
Isn't it already read?
it is, yes. I was going different part, but I'm gonna do the star thing.
Oh, okay. Yeah, that's a good idea.
That's what I was thinking of.
Yeah,
Thanks, Michael.
yeah. Synthesized language of these two sections. Yeah. Good call, Michael. Okay.
There you go.
And I added in the comment or in the chat function language that I had thought we had wanted to add at the end of 903.5.
And if I mean, isn't that essentially already in 707?
Is it?
So I'm looking, I think it is. Yeah, it's 905F or 905-1F.
Right. For just the
Well, 'cause that has
the
address
name of
too.
the foreign limited liability company's registered agent.
Not jurisdiction, also the name is.
Well,
it's got the
and
address,
that
yeah.
that's just, but F is just about in this state.
Um,
F doesn't talk about an agent who's in a different state.
Sorry, Cody, where's this language from that you put in the chat? ORS?
I'm frankly not sure. My note just says that we had decided we needed to add this.
Okay. Does existing ORS require that?
Oh, no, it's because, yeah, I have a note of similar. It's just because we have 5, the name and address of the mailing address of the company's registered agent in this state. And then I have a note if they have a foreign registered agent. But do we permit foreign registered agents for foreign companies in Oregon? I don't think we do.
I don't think we do either.
Well,
I
I
don't
don't know. I don't
We
think that,
don't.
yeah, I don't think I think we require them to have a local registered agent.
Right.
But this was just information that they are providing. It's sort of like additional information that they would be providing if they have a foreign registered agent as well.
I don't think we need that. Jamie, do you think we need that?
I don't think that we need it.
All right, let's ax it then.
Okay, well, we just won't add it. Okay, anything else on 903? (904). I had us adding 63,711 1B.
Is that the period of duration?
Mm-hmm.
It's 1B.
The computer's doing something weird. Yeah. Yeah. Anything else on 904? Oh, we lost Cody.
Oh, I've got a sick kid here who
Oh.
came in and needed authorization to watch the next movie. So
I
check in. So I just muted and paused.
I know how that feels. Good.
So many sick kids these days. Okay. So 905. Hold on. Under A, I have a includes but is not limited to.
Okay.
Yes, me too.
Okay.
And that's all I've got on the first part. And then, yeah, I don't have any other changes. Does anybody else have any other changes to 905?
I only had that there was somebody was going to ask Department of Revenue about Part B.
There was a lot of discussion about the impact of taxation, tax policy on this. That was the note I took.
Victoria, Willie, do you have any thoughts on B or C?
Valerie, could you repeat that, please?
Do you have any thoughts on B or C?
D or C, just a moment.
Yeah, so it's the doing business standard.
It's we may actually. Now, I know last time I took an action item, I ended up unexpectedly in the hospital and
Oh,
So sorry.
yeah, I'm fine now. Thank you, mostly. So can we put a pin in this and I will get back to you this time?
Okay, yeah, let's flag B and C for
Okay.
Department of Revenue to think about, but we have, I think our last session is going to be the next session. So if you wouldn't mind doing that the next couple of weeks, Victoria, that would be amazing.
Thank you.
Thank you. I appreciate it.
Can I add really quick, since we are still looking at these two sections? We have noticed that we've had a lot of issues with people trying to figure out if they actually should register, if they would need to register or not. So being able to use this to clarify and also match a little bit more with what Department of Revenue says, I think is a really good idea.
Yeah.
I
got
just
an
wanted to
email.
mention that as we're right here.
Well, and you may want to, Jamie, you may want to talk to PK and the folks in your office too. So we'll circle back to B and C. So add, Sandy, could you add flag sections B and C for Department of Revenue and Secretary of State review?
Sure thing.
So Jamie, if you wouldn't mind talking with your folks, that would be great too.
I will. Thank you.
Got it.
Okay, so let me make a note that we're going to circle back to this one. So this is 905.
905 B and C. Yeah.
5B and C. Next time. Okay. So we'll circle back to those. And then 906. 906. 906 is where I think we made a bunch of changes to A.
Oh, yeah.
So I have us striking the language in the first paragraph after for purpose of doing business in the state.
Yeah.
Yep. Through the bracketed language 3 lines down.
So it's all the way.
Yeah.
Oh, right here. Got it.
Yeah.
I see it. Okay.
So I have us striking that. Anybody have anything different?
And that was to basically maintain consistency with existing ORS.
Yeah, and because we don't have that fictitious name or alternate name stuff now.
Exactly.
I mean, other than like ABNs, which are.
I think if you're going to do that, you'd want to do it at the same time consistently across all of the entity statutes,
I
or
agree.
else Secretary of State would be in chaos in terms of its administration.
We don't want to create chaos for Jamie.
No,
We have
definitely not.
enough. We don't need any more.
Yeah, we're
Okay,
thinking
so-
of you, Jamie.
In that instance, let's also delete A1.
A1.
Right.
Oh, alternate name. Yeah, yeah. I had a note on that. I don't know why I didn't. I missed it. Thank you.
Going back to A, sorry, I missed it just now. I have what you have as well, but on that first sentence, I thought we had wanted it to read where it says that whose name does not comply with section 112, have it say must register to do business in this state under the company's name with the addition of its jurisdiction of formation.
Is that the 717 language?
I believe so. I don't have that part of the note, but
Yeah, I think it's 717 sub 3. Oh no, 717 sub 4.
yes, there it is.
So I think we just add a comment saying, Sean, make this consistent with 717 sub 4.
Got it.
And it's 60, it's is it 63 717 sub 4?
Oh, ORS 63. Thank you. Got it.
Anything else on 906? Oh, and 3, the bracketed language,
Yeah. Oh, that's gone, right?
I think we deleted that, right?
Yeah, because it involves fictitious.
Right.
Well, I thought we had it I thought we changed it to say a name the company is authorized to use under ORS chapter 648.
I don't have 648.
I don't even know what that is.
That's the Indian.
I have a reference to something about Burger King in here.
Wow.
Company adding to do business under two names, blank LLC Burger King. I have no idea what.
Oh,
that is.
648 is assumed business names.
Oh, well, you know.
That's the assumed business name statute, which is what Rolka's referring to here.
Oh,
So I think we want 3 to be as is. We just replace the bracketed text with ORS
Yeah.
chapter 648.
Yeah,
so it's ORS, you said it was
chapter
Just
648.
chapter 648, okay.
Awesome.
And then on B, because again, we're getting rid of this alternate name business.
Mhm.
I think what we need to do is I think we just delete everything after subsection, the reference to subsection A.
Okay,
Yes, I mean, I think the idea is that Sean is gonna finesse it, but
do you want me to strike through it?
yeah, go ahead and strike it through. But the idea is really that Sean's going to be cleaning this up.
It's good to guide him though, that makes sense.
Okay, I have 907 as is.
So I had 2.
Yep.
908, I have some handwritten notes, but no changes.
I had this change here in C
Let's see. what do
from my notes. Or sorry, it's in 2C.
2C. Do we want changes?
I don't have that change.
I don't have.
I
the
have a
changes.
note that says flag for legislative council
Okay,
for subsection C.
Yeah.
for some, okay.
I'd rather. Oh wait, that's not 2C. Wait, where are you?
Oh, it was in my notes, it was an addition.
Oh, yeah, that was,
Yeah, because it's kind of confusing the way it.
Yeah,
Addition. I don't have that addition.
okay.
I don't know that it's a bad idea. What do you think? What do you guys think?
The addition of C.
Yeah, Jamie, would that be helpful to you guys?
I think so. I think it would be good.
Because I don't think it hurts anything.
Mm-mm.
Okay. Anything else on 908?
I have a question. Why would we require that in 908 though?
Hold on.
Why wouldn't we require that in the other part, the 903?
Well, because see, that is.
Or I mean, this is one of the things that we wanted. This is one of the things that
I
we
think, yeah,
decided we do want in 903.
Yeah, I think we're adopting 707 wholesale, right, in 903? Go back. I'm making this
Oh.
backwards again.
That's the one that we wanted to do, the synthesize.
Yeah.
So I guess I just don't understand why it would be a 908.
908. Well, 908 is withdrawal or conversion, right?
And also adding a C, like there's no, that's, what's in red there as C looks like it's the end of a sentence. but there is no beginning to that sentence.
Oh,
No,
that's true.
I agree with that. And I didn't have this actually added.
So,
I think if we've got it in 903, we don't need it here.
okay, I'll just get rid of it then. I just probably misunderstood my own notes.
Well, I mean, we're all not, I have to read my own handwriting, which is a horrible, horrible thing to do. So,
So I'm just gonna get, because we already added it up top, I'm just gonna
Yeah.
get rid of all this. That's fine.
yeah, I think that's fine.
Yep. Just gonna take a minute to clean it up.
Okay, 909, transfer of registration.
Sorry, just need a minute here. Just gonna get rid of this.
Okay, so 909, I have under sub 3, the deletion of everything after 112.
Oh, because it's alternate name again.
Yeah. But that's all I've got under 909.
Yeah, but no, we would delete everything after the word converted.
Is that right?
Oh, right, yeah.
Yeah, that's
Yeah,
right.
yeah, Make it grammatically correct.
Yeah.
Anything else under 909?
Well, yes. We had wanted to add relevant language from 707 here. We wanted to add, 707 1C and D, for example.
Oh.
And then an analog to 707 2. Is
Do
what
we
my
need to
notes
do that
show.
though? 'Cause I don't
Uh,
have that, and I think if we've got the changes we made to 903, it should cover it, right?
So I have-
Well, go ahead.
I just have a note that says it needs conforming changes similar to changes to 903.
Yeah, that's the gist
Okay.
of what my notes say too. I mean,
Yeah,
this
so
is
go ahead.
listing out the same kinds of information. It's a different concept. This is a transfer registration rather than an initial registration.
So Sandy, go ahead
Mhm.
and add a note, one of those asterisk notes at the bottom after, yeah.
After 909, yeah.
Mhm. And just say what David basically just said.
So it's conforming. Dave, can you say that again? I'm sorry.
So this section needs conforming changes similar to changes to 903.
And I think you've been adding just the LC at the beginning of that.
Yeah.
Yeah.
Okay.
Anything else under 909? Um, 910. I had under 910 A1 insertion of the word timely before the word pay.
Oh, well, I think I got, my notes show the same thing, except for what we don't add the word timely, but we get rid of the not later than clause.
Right, but I think if we add timely and we get rid of not later than, it has that same,
I'm happy to add timely.
yeah.
And we get rid of.
And then delete not later than, yeah. Because that will
Yeah,
allow
yeah.
Secretary of State to control their own deadlines.
Yeah.
And similarly in 2.
So the other thing, are we actually keeping tax, interest, or penalty in as well?
Yes.
We don't pay taxes to Secretary of State.
Well, but it says any tax required to be paid under this act or law other than this act. And
Well, paid to the Secretary of State.
right. I mean, I guess in short, if there's no tax that's required by anything in Oregon law to be paid to the Secretary of State, then I think having this language in here is harmless.
No, I don't think, well,
I think we've gotten rid of it in other parts.
yeah,
This
I think so
first
too. I
time.
think it just creates additional confusion. So I would delete the word tax in there to the extent there's interest or penalties. I think that's a different matter.
Okay.
Tax interest or penalty required to be paid. Yeah, and that's fine. Okay, so under 2,
Mm-hmm.
timely delivered to Secretary of State for filing.
Yep.
And it should kill the biennial language.
Because it's annual, yeah.
Yeah. Jamie didn't like my suggestion. We moved to a biennial system.
So not to beat a dead horse, but my notes also indicated we were in like the first one with the fee part, we were going to say match it to be closer to 63,737 subparagraph 2.
Yeah.
Okay.
So, and could
Should we
you
note-
please fix that timely?
Oh, yes, I can.
Yeah. and I
Oh, my
think-
goodness. Wait, that's not spelled right either.
No,
There's no E.
I mean, there is an E, but not where it is currently.
No, it's Timely. Yes,
Right,
yeah. Good.
Yeah, I mean, I think David, would it just be worth a note to Legislative Council just that we need to make it conform to 63,737?
Yes, that would work. They say within the time prescribed by the statute, and they just reference fee.
So if in the note I had, we already had, so there's already notes as or a preserve policy from 714. Is that right? I may have written that down wrong.
Well,
Because that's
I think
it. I'm sorry.
generally speaking, we want the restrictions that are currently in 737.
Are we actually
So-
adding this additional section? I had that as a note as well.
Well, because that's the sub 7 language.
Right. Yes, exactly.
You know, so I think after that consensus statement, do
Yeah.
a carriage return and then 2 asterisks and just say, LC, please make this consistent with 63,737.
Yep.
So we also had discussion about what other subsections of 737 to add. So does that comment cover that?
I think so. I mean, so I don't think we have any intent to change what's in 737 now, right?
Right.
Okay. Anything else on 910?
Well, I thought we were wanting to add stuff from 741. I see Cindy has a note there about 63,714, but maybe that's
Oh,
meant
that
to.
I'm sure I just transposed that. Yeah.
I have a note saying that we wanted to add 741 sub 4 and 5.
Yeah, I mean, we could add so under the LC comment, just make
Mhm.
it add in and 63,741.
Okay.
Because that's really the process, right, of how you deal with a revocation.
Yeah.
And I'm okay punting that to Sean.
And on 910C1, where it says 60 days up there, I thought we had decided to keep it 45 days consistent with ORS.
Yeah, but it has to, I mean, you can, well, go ahead and highlight that, Sandy.
Yep.
Because we want the Secretary of State's rules to be controlling here.
Should I add 45?
Question mark, 45 question mark.
Sure.
I also have a note that we had wanted to add a counterpart here to something similar to section 709 and 10. So, 708 talks about administrative dissolution. And then 709 talks about how you can get reinstated, and section 710 talks about how you can get review of a reinstatement decision. And here we're talking about termination of registration for a foreign LLC. And there isn't a similar ability to get re-registered or to have a re-registration decision be reviewed. My note indicated that people wanted to have similar provisions to
Yeah,
what are
but
in
good point.
709 and 710 for a foreign LLC.
I don't have that note, but that does make sense to me. Anybody have any concerns about that? So Sandy, that would be after 741 there, it would be, no, go back.
Sorry. Oh, in the same one. Yep.
It'd be a comma. Include procedures for reinstatement, etc. in current ORS. And that's analogous to.
Analogous to. No I.
And what were the sections that you had there, Cody?
It's counterpart to ROLCA sections 709 and 710.
Oh, okay.
And this is already this concept is already part of ORS in 63, 744 and 747.
Yeah, appeal from revocation and grounds for revocation. Yeah. Good. Any other thoughts about that?
No.
Okay. 911.
So this is where I had this 744 and 747 for some reason. I may have put it in the wrong place, but that's where I had it.
Withdraw. Oh, I see what you did.
I probably just wrote it in the wrong place.
So, well, I mean, I think
The 911 is about a voluntary withdrawal by the foreign
Right.
LLC. Whereas, 910 is about the SOS kicking you out.
yeah, they screwed up somehow. So I think it makes more sense to put it in the prior section.
Okay. So let me
Um,
get rid of it then. Just to make sure it's not here anymore.
do
I don't want to confuse anyone, so I'm just gonna get rid of it.
yeah, go ahead and delete those. And the 744.
Yeah. Come on.
If it's in the prior section, does that mean that they don't have the ability to reinstate if they, actually, never
Uh-huh.
mind. I just answered my own question.
Yeah, I do have a note that we want to incorporate 63,734 1E.
As
I
a
have
part
that.
of 911.
Yeah.
Okay.
Mhm.
So, hold on one second. Section.
We wanted to add that as A5,
Right.
911 A5.
So it's
And then
so 911. It's
carriage return. Asterisk.
Yeah.
And then it'd be LC add 63, 734, 1E as sub 5.
1E. Oh, I know. Yeah,
Element.
1. Yeah, 1E as
New section 5.
Okay.
Okay. And then finally 912, I have no changes for 912.
Yeah, me neither.
I just
We
had,
are-
You just what, David?
I just had okay.
Okay.
Yeah, and that's amazing timing. We're at 11:59.
Yep. So let's finish up with, I mean, I think we can finish next time.
Oh yeah, definitely.
So, great
But
job. Great job.
Real quick, if anyone wants to add any of your notes in 10 and 11, my notes are a bit convoluted. I'm going to work on mine more by the time we work on that. I was working on it again last night, but if anyone else has notes, please add before next meeting.
Yeah, and would you mind, Sandy, sending out a thing to that effect, saying, you know,
Sure.
we anticipate finishing this up on the 20. So our next meeting is Monday, the 23rd.
Yeah.
And I'll just throw out that there were 3 orphan sections of the ORS that are not in ROLCA that I think that we still had some questions about.
Oh, I thought we covered those already.
Well, we went through them once, but there were 3 that I think weren't finalized. One was
Okay.
63.810 regarding
Okay.
taxes.
Okay.
All right, I'm
One
taking a note.
was a 960 regarding the dentists. And I think
So
Sandy was gonna-
960, I'm on it. I've been in touch with the dentist. The first person I talked to appreciated that we asked, but referred it to colleagues. But I hope you'll hear back by our next meeting.
Okay, and then on 63074, I have a note that Valerie was going to check with DOJ charitable activities section.
Okay, I dropped the ball on that, so I'll do that.
And I also have word out. I also have been in touch. I just haven't heard back from the right person about in section 302 related to the title industry. Just a note on that.
Okay.
But
Yeah,
the dentist, I think I'll hear back from soon because at least the right people know about it now.
Okay,
Yeah.
so we'll start with those sort of follow-up items, and 905 B and C. Victoria and Willie, if you guys could take a look at 63.810 too, that would be really helpful.
Yes, we will. Thank you.
And then, but I think that, you know, with those items, and then we should be able to finish 10, and then 11 was pretty straightforward. as a
Yeah.
definition.
Very much so.
Good. Good. Good.
Thank you all. That was a good meeting.
Yes, thank